Do you understand that that is what you've been charged with?
I have a right to speak, do I not, Judge?
Not at this point. You don't put Mr. Hoffman back in his cell.
And that's my attorney right there, right?
He's not your attorney.
If he's not my attorney, then I want to stop until I have an attorney. I didn't understand any of that. I don't know how to read. I'm telling you that. 7th grade education. Can I speak to you, Honorable Corey J. Wiggins?
This dumbass doesn't have a clue about how the arraignment process works, despite his having been through it so many times that I lost count when Judge Wiggins read them into the record. He doesn't have a clue how to adult, either. All Judge Wiggins wants is to get through this arraignment. Even on the best of days with the best defendants, it takes 5 to 10 minutes. But with this dumbass, it took over an hour. Through the magic of video editing, I cut out the boring parts, and I left a svelte but interesting 14 minutes. Let's roll, nerds.
Person at the jail, what is your name?
My name is Joshua Hoffman.
All right, this is case number 253657SM, the people of the state of Michigan versus Joshua and Michael Hoffman. We're here for an arraignment. Mr. Hoffman, you met with somebody from the Community Corrections Department and gave them some contact information. Is that information accurate?
Yes, yes it is.
Did you have the opportunity to meet with somebody from the defender's office today?
Yeah, and I did meet with them. I just don't know why I met with them.
Okay. Well, they're required to meet with you. That's probably why.
What events?
What's that?
What events are you speaking on? I'm right here with you. I'm trying to figure out everything along with everyone else. All I know is I was aggravated at my roommate.
Hold on. Mr. Hoffman,
yes, sir.
Don't say anything. I don't want you to say anything about the case, all right? Because we're making a record and a prosecutor's present, so I don't want you to say anything that could cause some issues for you. So
yes, Judge. Yes, Judge.
Let me do what I need to do, and I think that's going to answer your question for you, all right?
Yes,
so I have a complaint that alleges that on or about August 10th, 2025, in the city of Cadillac here in Wexford County, it is alleged that you did commit the offense of domestic violence upon William Scott, a resident or former resident of your household. That is a 93-day misdemeanor and or a fine of $500 with consecutive sentencing may be imposed if the assault happened in place of confinement. Mr. Hoffman, I'm not asking you if you agree with the charges, but do you understand that that is what you've been charged with, and that is
I would like to press charges if that's what I am being charged
Mr. Hoffman, this is going to go a lot easier.
I have a right to speak, do I not, Judge?
Not at this point, you don't.
Why not?
Mr. Hoffman,
I would like
process. Corrections, I have a docket I have to get through, so can we put Mr. Hoffman back in his cell, and I will get back with him.
I'm asking you a simple question. Can I press charges against him?
Thank you, Corrections. All right, we are back on the record in the people of the state of Michigan versus Joshua Michael Hoffman, case number 253657SM. Ms. Lawrence joins us in the courtroom. Mr. Hartel, are you able to see and hear the court?
I am, Your Honor. Thank you.
And Mr. Hoffman, are you able to see and hear the court?
Yes, Your Honor. I'm able to see and hear the court.
Mr. Hoffman, I know you had a lot that you wanted to get off your chest. I want to just let you know that I am not the person that you need to talk to about filing charges. You can talk to law enforcement about that, or you can talk, if you decide that you want an attorney, you can talk to your attorney about that as well, all right?
Okay.
So I had left off with you, the last thing I recall was that we had gotten through the charge and I had read the penalties, and you acknowledged that you at least understood the penalties in the charge. Is that accurate? Not that you agree with it, but that you understand that that's what you've been charged with.
Can I ask what the charge is again?
So the charge is domestic violence, that you did make an assault or assault and battery upon William Scott, a resident or former resident of your household. That is a 93-day misdemeanor and or a fine of $500 with a consecutive sentencing might be imposed if it happened in a place of confinement, which is essentially jail. So we know that that doesn't apply. Do you understand those charges and the potential penalties? Not if you agree with them, but do you understand that's what you've been charged with?
Yes, Your Honor. Absolutely, I do.
I can't remember, did I ask you if you had signed an advice of rights form, talked about your rights to a trial and your rights to an attorney?
No, you had, yeah, I signed that with Mr. Robert Hartle there. Did I not sign that with you? That's my attorney right there, right? Ain't that what we did earlier?
He's not your attorney.
If he's not my attorney, then I want this stopped until I have an attorney. Right? I have the right to do that, right?
Hold on.
I'm not answering any more questions.
That's fine. Just let the judge talk.
All right, so since we're not sure whether or not you've gotten your pretrial rights, I'm going to go through those with you. If you require accommodations to use the court because you've given up the rights that we just went through, you also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, where a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole.
Plead not guilty. Plead not guilty.
All right, still have to go through these. You can be sentenced to jail fines plus costs. The courts will tell you on the record the name of the offense and another similar relationship. Do you understand those rights that I just went through?
I don't understand any of that. Can you read it again? I didn't understand any of that. I'm gonna need you to read.
Let's do this. Let's hand him an advice of rights sheet and let him read that then.
I don't read too well. I got a 7th grade education, sir.
All right, then what I'm going to do is I'm going to put
record right now.
I'm going to put you and Mr. Hartel in a breakout room.
That doesn't work. I don't know how to read. I'm telling you that. 7th grade education. What was all that you just said to me, sir? Can I speak to you, Honorable Corey J. Wiggins?
All right, we are back on the record in the people of the state of Michigan versus Joshua and Michael Hoffman, case number 253657SM. Mr. Hartel, are you able to see and hear the court?
I am. Thank you, Your Honor.
And Mr. Hoffman, are you able to see and hear the court?
Yeah. Yes, Your Honor.
Mr. Hartel, did you have the opportunity to go through Mr. Hoffman's rights with him?
We did go over those, yes, Your Honor.
All right, Mr. Hoffman, did you understand those rights as your attorney went through them with you?
Yes, Your Honor.
All right. You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one will be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, request the appointment of an attorney, or represent yourself?
Whatever is going to expedite the process and get me kicked over so I'm not doing dead time on parole.
Well, the choice is yours. I can't make that decision for you.
What was the question again?
Do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
The appointment of an attorney, along with my entry to a plea of no guilty right now.
The court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That is where your appointed attorney and a representative from the prosecutor's office will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, historically, I show in 2012 an operating while visibly impaired, in 14 a driving while license suspended, in 17 an operating or maintaining a lab in possession of meth, 18 UDAA, and a B&E of a building with intent, in 17 2 B&Es with intent, an assault and battery, and then 3 more B&Es with intent. In 20, there was a use of a controlled substance, 20 assault and battery, and malicious destruction of building.
27, excuse me, sir. Apologies.
In 23, a larceny less than $200. In 22, a resist and obstruct. There was a 7411 case in 2012. In 10, there was a shoplifting, which was out of state. And in 17, there was a fail to appear for a fingerprintable charge. He's currently...
Sir, why are we going over all this right now? This is an advice of rights. What you just did right there is totally against the law, and you have no right to be mentioning evidence from prior cases in this case without me being found guilty first. I have a right to have all this expunged from the record, and this will be on the record. I will mark. What time is it?
15:24.
15:24.
Defendant is also on parole with the state of Michigan for the B&E with intents and UDAA. Corrections, is there a hold on him?
Yes, there currently is a parole detainer.
Those are the same thing. I don't blame him. What happened was, Your Honor, is I was going to leave the house. My roommate had my
Mr.
tool
Hoffman, you
bag.
have the right to remain silent. I don't want you to say anything that can be used against you.
This shit sucks.
Any comment regarding bond, Mr. Hartel?
Talk to me in person.
Yes, Your Honor. Thank you. As was noted, I do believe there is a parole hold on this defendant, so some of this argument may be academic. However, I would ask the court to set a small nominal amount of bond so that if he is able to resolve his other issues, that he would be able to then be able to afford the bond, perhaps $100, something very nominal like that. I believe that if the court had any concerns for public safety, they could be overcome with bond conditions and no contact order with the alleged victim. My apologies. I'm not trying to take anything away from his defense strategy, and whoever's assigned, be it myself or someone else, will go over that with him later. But I would again ask the court to keep the bond as low as possible. Thank you.
Thank you. Prosecutor's office?
Your Honor, I'll try and keep this short. This was allegedly between the defendant and his roommate. He had pushed his roommate down the stairs, accused him of taking his marijuana vape. We would ask for a no contact order with the victim. Additionally, given the defendant's extremely long criminal history, as well as the fact he is on parole, I did speak with Mr. Saladay briefly, and he did inform me this is not the first issue he has had with the defendant being on parole. Given that, then people would ask for a $5,000 bond. Thank you.
You said this is allegedly over a vape pen? Marijuana pen?
Marijuana vape, yes.
All right, the court will set bond as follows. Mr. Hoffman, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm going to order no controlled substances, including recreational marijuana. You'll be subject to random testing. There will be a no contact with William Scott. No contact means no contact of any kind, not by you, not by phone, Facebook, Messenger, any other social media, or anybody acting on your behalf. Defendant is not to act in a threatening, intimidating, or harassing behavior. The defendant does have a couple assaultive crimes in his past. An assault and battery in 20, an assault and battery in 17, resist and obstruct in 22. So I do find that a monetary bond is appropriate. I will set a cash or surety bond at $2,500 cash surety. And I should have mentioned also that I had reviewed the praxis, and the praxis scores him at a risk level 3, which is medium risk. I believe that is properly scored, at least given the information that we have. All right, Mr. Hoffman, you'll be receiving your next court date there at the jail. If you are able to post bond, you'll need to report to community corrections here at the courthouse and get signed up for testing.